Hi, everybody. This is Samantha from the Law Offices of Samantha Wolfe, and welcome to our monthly virtual seminar. For the month of February, we wanted to do a question and answer session. We had clients or referrals email us questions prior, and I'm happy to answer them, and then we will have anybody on here is welcome to ask any questions live. So thank you so much for joining us. Before I get started, I will ask Jess to share the screen quick, only so that we can talk about next month's seminar before I jump into it. So please know that our office is located at 20 East 6th Street in Suite 206 in Waynesboro, PA, and you can reach us at 717-655-2676. And we always offer consultations at our office. You're always welcome to call. We'd be happy to chat with you. We do have a YouTube channel and a website where we post all of our videos after. So if there's anything you want to check out afterwards, you can do that. This is our mission statement. This is one of the reasons that we like to do our monthly virtual seminars, because we want to make sure that we're providing education to clients and referral sources. Next month, March 7th, we're doing tax stuff. We're calling it Snap, Crackle, Tax, and it'll be from 12 to 1, and we're going to go over all of the tax rules for 2024, understanding that, it's really going to apply when we're filing taxes in the spring of 2025. But I thought it would be good to go over all the fun tax stuff. So we'll do that next month. So you can be sure to check that out. Okay, Jess, you can go ahead and stop sharing. Like I said, welcome. This month we're doing Ask the Legal Lady. So I have some fun questions, and I appreciate everybody who sent in questions. So I'm going to start there. I'll start with the questions that we got. Then here at our office, we thought of some other questions that most people ask, so we thought we'd answer those. And then if anybody has any questions that they feel comfortable asking live, we can do that as well. Okay, so let's start with the first question that I have. So the first question that was submitted was, at what age should an individual start the estate planning process? So I'm glad I got this question, because this is actually one that in our marketing meeting we had talked a little bit about that we wanted to address. So I'm a firm believer that once you turn 18, everybody should at least have the power of attorney documents and your last will and testament. If you were to ask me what age is ideal to do planning, I would tell you at any age over 18, because you want to make sure you have those power of attorney documents and last will and testament. That being said, there are certain life events that might seem to indicate that you should do estate planning documents. So the first is that if we have anybody who would be getting married and would want to start naming their spouse, for example, as their power of attorney, or would want to update their will to include the spouse, we always recommend marriage as being a life event that you might want to make sure you have those estate planning documents, or even if you already have them, you might want to update those estate planning documents. Another event that would trigger updating estate planning documents would be if somebody's having children. So when you have children, you need to name a guardian and a custodian under the will. So we always recommend, if you're having children, to have or update your estate planning documents. That would be another life event. And then usually if there's something changing in your life, so unfortunately there might be an event, you lose a spouse, you lose a child, somebody close to you that you might have named or wanted to provide for, we recommend that you update your documents then. We also recommend that you update your documents if you're nearing retirement age. It's always a good time to talk about what are my beneficiary designations, what does my estate plan say. It's a good time at retirement. And then I think my guess is this is most likely what the question was kind of targeted towards. So when we're talking about like long-term care planning and planning for the second half of life, what's a good age to do that? And even if we have clients that don't end up doing trusts to protect assets, there is a 5-year look back period in Pennsylvania. So I always suggest that people around the age of 50 should talk to somebody about it so that they know, hey, we should be doing something or we should not be doing something. Again, even if they ultimately decide not to do the trusts, at least they've had the discussion. And I feel like the age of 50 is a good age to do that, because if somebody would decide to do the trust, they'll make it through the 5-year look back period. The question that was not asked that I'll go ahead and answer is, what is the age that we see most people meeting with us to do estate planning documents. The average age is usually about 62 is when we see clients meeting with us for estate planning. So I hope that answered the question. I tend to make every question a little bit more long-winded than it probably needs to be, but hopefully I addressed that question. And I will tell you personally, because that's the best way for me to kind of gauge that, my parents did their asset protection planning trust when my dad was about 62. So it's a good age to be doing it. So that's when I had my parents do it. The next question is, do trusts protect against lawsuits? So because it's me and I have to expand on everything, let me start first by saying that there are a whole bunch of different kinds of trusts that you can use. There's special needs trusts, there are revocable trusts, there are irrevocable trusts. Saying that you have a trust or asking about a trust is like saying you have a car. Many different variations, many different models, styles. So when we're talking about specifically creditor protection, we use what we call protector trusts in our office, and they do protect against all creditors. The biggest creditor that we think of as we're aging is a nursing home. So that's why sometimes Medicaid trusts or long-term care planning trusts are used in other areas, because it actually protects against any creditor. But as we age, we think of a nursing home as being the biggest one. Now, a nursing home, you have a 5-year look back period. For other creditors, you do not have the look back period. The rule of thumb is that as long as you were unaware of any lawsuit or pending litigation, if you transfer property into an irrevocable trust, there's no look back period against other creditors, just a nursing home. So I want to make sure to mention that. The other thing I wanted to mention is that the reason that you get creditor protection is the way the trust is structured. So even if you have an irrevocable trust, depending on the provisions, you might not get the creditor protection. So the type of trusts we use are very specific, where, and I'm going to take my parents as an example because that's easier for me to be able to explain it. So let's say my mom and dad created an irrevocable trust and they transferred assets into that trust. And in the trust, maybe they named me as the trustee, and then they named my sisters and I have 3 sisters, there are a total of 4 of us. Maybe they named all 4 of us as the beneficiary of that trust. That type of trust does get creditor protection, but it also limits my parents' accessibility and flexibility with the trust. So in Pennsylvania, you can create an irrevocable trust where my mom and dad can serve as the trustee and make all investment decisions, buy-sell decisions, any day-to-day management decisions my parents can make as the trustee. But in Pennsylvania, if they take the power of distribution that normally the trustee has, and we give it to a new position that we call the trust protector, that's why we call the trust protector trusts. If we give the power of distribution to that trust protector, then mom and dad can keep the most flexibility they can under Pennsylvania law, plus they can get the creditor protection. So that's why when we're talking about trust, you can make it more limiting, and the benefit there is there might be some additional tax benefit, or you might be trying to remove it from your federal estate, but you can do a trust where you can be the trustee and still have a lot of the power or majority of the power, but still get the creditor protection. And that's from all creditors. Could be a car accident, a lawsuit, maybe you have rental property and somebody falls on the property. These type of trusts do protect against all creditors. The reason that they protect against all creditors is because if you set up the trust and transfer the assets into the trust, but you're not a beneficiary and you do not have the power to make distributions, then you get the creditor protection. So again, I'm sorry for the length of that answer, but yes, trusts do protect against lawsuits. That would be considered a creditor type. Like I said, the biggest creditor that we think of when we're aging is a nursing home. So the trusts that we use for nursing home planning also do protect against other creditors, which is why we have business owners that also use those type of trusts. We have doctors that use this type of trust because it's so flexible and you can use it for so many different things. Next question is, can trust be dissolved after we have passed. So again, I'm going to use my parents just because it's easier to give an example. So you have two main types of trust when we're talking about dissolution. You have a revocable trust and you have an irrevocable trust. So if you create a revocable trust, you can make it so that at any point during your life, you can terminate the trust, you can fully revoke it, you can pull assets in and out because it's revocable. You have that flexibility. Then you can set up the trust structure to say, when I pass away, this is how I want my assets to be distributed. So for example, my parents could set up a revocable trust. They could transfer assets into the trust while they're living. When the second of them passes away, this type of trust avoids probate, and then the trust would say upon the second spouse's death, it can pay outright, for example, to my sisters and I, which means that the trust dissolves and we each get a 25% interest in the trust assets, or maybe the trustee liquidates or sells the assets and then distributes the sale proceeds 25% to each child. That would be one way that you could do it. The other way that you could do it is that you could say when the second spouse dies, when mom and dad, both of them have passed away, and it goes to my sisters and I, it can go in trust to each of us and we can actually each have our own trust. The benefit of doing that would be if I would get married and get divorced, that divorcing spouse is not entitled to my 25% inheritance. Or if I would be in a car accident and somebody is suing me, the creditor can't attach to my 25% inheritance. So we do have some clients that even though you can make the trust terminate when the second spouse dies, they choose to keep it going for the next generation because they want to provide the creditor protection for their kids and grandkids. The other thing that that would do is that I would give my parents the ability to say, well, if Sam dies and there's money left as in her inheritance, her 25%, I'm going to have it go to her children. Or if she doesn't have children, I'm going to have it go back to her other sisters, or I'm going to have it go to our grandchildren. It gives you the ability, if you want to, after you've passed away, to be able to control and direct those assets where you would want. So the short answer to that is yes, trust can be dissolved after you've passed. You can either make it so that the trust continue, you can make it so that the trust terminates, or you can let it up to the beneficiaries to make that decision. And if we're creating something where it's going in trust to the kids, we typically do have a provision that does allow the children to be able to terminate it under certain circumstances. So for example, maybe if all the beneficiaries agree, or maybe if they appoint an accountant or an attorney who reviews the trust and what's happening and decides that they are okay with terminating it. Or it might be that it's no longer economically feasible to have the trust. Maybe it's costing more to do the tax returns, and so you can allow your trustee or beneficiary to terminate the trust. So you can automatically make it dissolve. You can also give provisions that would allow certain individuals in the trust to be able to dissolve it as well. And the trend right now is that we're having people do it in cascading trust, which means that when both my parents pass away, it's going to my sisters and I. Most of the time, clients are choosing for it to be divided in fourths, and then each child has their own trust. That just seems to be what the trend is. But you know your beneficiaries, and you know what makes the most sense. You know what obstacles they're facing in life, if they have creditors or marital issues. So we just like it to be specific to what you want. You can do it per beneficiary too. So my parents could say, Jess's share is going to pay outright, but Sam's is going to pay in trust. So it gives you the ability to pick and choose how you want it to pay out and if you want the trust to dissolve. Okay, hopefully that answered that question. Next question is, should I be taking steps to protect some of my money before moving to a retirement community? So the answer to that is, it depends. So here in our community, we have some really great long-term care facilities or retirement communities. We have some continuing care retirement communities or planned life communities. We have some traditional long-term care facilities that might offer skilled nursing. We have rehabilitation facilities. So I guess the answer to that depends on what your situation is. So I know from experience locally, we have Quincy here, and Quincy is a facility where typically you sign an admissions agreement, and then if you're going to move into maybe a cottage, you put a certain amount down or a certain monetary amount down, and then Quincy provides along the entire continuum of care, meaning that if your physical condition deteriorates so that you would need a higher level of care, they still provide that care because of what you've paid in or invested in their community. So I know that Quincy has a benevolent care fund, and if you would run out of funds, then you would be able to use that. They also apply for Medicaid. That being said, when I review the Quincy admission agreement, sometimes clients have asked me to look at it before maybe they move into the community. And there is a provision in there that says that if you're going to be moving into the community, you can't transfer assets and try to make it so that they're not available to them to use. And that makes sense. It aligns with kind of the thought being that, there's a 5-year look back period. And if you are wanting to protect assets, you want to be doing that prior to when you move into a retirement community. Now, we had a client who did a trust, transferred the assets into it, and then actually decided they wanted to go into Quincy prior to the 5-year period, the 5-year look back period running. And what the facility did is they had the trust protectors, who were the children, sign off saying that if mom needed anything less than skilled level care, for example, assisted living, independent living, personal care, if mom needed any of those levels of care, that they were going to make the assets in the trust available to pay for care, which does comply with the Medicaid rules, because you can't get Medicaid as a way to pay for your long-term care unless you're assessed at skilled level. Skilled level care means that a physician is saying that you need assistance with at least 2 out of the 5 daily activities of living. Daily activities of living are things like bathing, dressing, ambulating, all of that. So if you need assistance with 2 out of the 5, then medically you're assessed at skilled level care. Medicaid is only available to pay for skilled level care. So when I had the client that was going into Quincy at independent living level care, it made sense that Quincy was saying, well, you have to use the assets in the trust if mom exhausts all of her other assets outside of the trust. And that does comply with what the Medicaid rules are, because if mom's not assessed at skilled level, then Medicaid wouldn't be an available resource. And the only thing that I was telling my clients would be that the nursing home obviously determines the level of care typically once you're in a facility. So if you disagree with the level of care, you would have to get a second opinion, and the facility would be able to say, well, you're not at skilled level care yet, so therefore you need to continue to privately pay. So the only downside in that case was I just reminded the kids that, obviously the facility is going to make a determination about the level of care, and if it's anything less than skilled, then the trust assets are available. That being said, if mom's physical condition would deteriorate and she would need skilled level, then Quincy does follow the fact that a Medicaid would be applied for, or the benevolent care fund would be used if she exhausted all of her funds. So as we're talking about taking steps to protect assets, I think it depends what type of community you want to go into. Sometimes you want your assets to be available to them because you might be doing like some sort of buy-in or purchasing a cottage. However you want to look at it, you might want those assets to be available to pay for care. However, if it's something where you're not sure about the level of care or what's going to happen as we age, you're going to want to do the trust planning prior to going into a facility, because you want to make sure you're being fair to them and to you. So you don't want to be doing it at the last minute, trying to transfer assets into trust. You want to make sure you're doing it in plenty of time. And then, like the situation with my client, if you need care within the 5 years, then Quincy's just going to say that the trust assets are available until you are at the level that you can receive Medicaid. So I think the answer to that is yes. If you want to make sure you're protecting assets, you do want to do it prior to moving into a retirement community. And you want to have an honest and open discussion about it to make sure that both, if we're dealing with a husband and wife, both spouses are comfortable with the way that you're going to approach long-term care. Like I said, when you're dealing with a facility like Quincy or any other planned life community, the benefit you have is once you are admitted into that facility, typically they provide for you along the continuum of care. So you want to have that discussion and know that if you do opt to do the trust, you're not hiding those assets. You are going to disclose those assets to that facility, and then they're going to make the determination as to whether or not they will accept you based on what assets you have outside of the trust and what assets you have in the trust. And then you can make the determination if you want to pull assets out or if you want to further fund those trusts. So I hope that answered the question. And if any of these, if you're the person that submitted the question and I'm not answering what you were trying to get at in the question, once I go through them all, you're welcome to jump on in and I can flush out any of those answers. All right, the next question is, what steps would I need to take to set up a scholarship? So I liked this question because it's not a question that I get every day in client appointments. So let's talk a little bit about a scholarship fund. So it's always great if you're charitably minded to be thinking about how you want to handle that. So there are a couple of options that you have. So the first and the easiest one is to use a donor advised fund. So a donor advised fund is typically a fund that's with a financial advisor where you set aside funds and you're kind of earmarking it for charity, but then you can designate the charity at any future date, but you're setting aside those funds. And so donor advised funds are a great way if you are charitably minded and you want to go ahead and earmark those funds, but maybe you haven't completely decided what charity, or you might want to change it from year to year. A donor advised funds allows you to do that. So if you're thinking that you want, let's say Penn State, that's my alma mater. So let's say that I wanted to create a scholarship fund at Penn State. If I create a donor advised fund, I could certainly have Penn State listed as the charitable beneficiary of that, and it could go towards an already existing scholarship fund that they might have. So for example, if I wanted to leave money to women in leadership, or women in the legal field, whatever that would be, you want to check with the institution. Maybe they already have a scholarship fund that you can just contribute to, whether it be in your will, you're designating a certain percentage or a certain amount to that scholarship fund, or whether it be that you're allocating the donor advised funds to that scholarship. Either way, always check with the institution and make sure, do they have something already in place? Because then that means less work for you. So that's one way to handle it. The other way you can do it is that you can set up a scholarship fund. I have done that previously, and I've also done it where I have set up a nonprofit or a private foundation. So there's a lot of different ways that you can do it. But the thought being that you have to think about, how much are we considering setting aside for the scholarship fund? Is the large amount, like, are we talking over 500,000 that we want to do a scholarship fund? Are we talking about 100,000? You know, what's the monetary amount we're dealing with? And then the next question is there going to be criteria for how the scholarship is awarded? And is it up to the institution, or is it something where you're going to appoint certain individuals? So I've done a private foundation where we have had like a scholarship fund that's been awarded. I've done that before. I've also actually worked directly with the institution, whether it be a medical institution, it could be an educational institution. They have great legal departments and charitable donation departments. And so usually that's a great place to start. It's calling them and saying, how do you guys go about setting up a scholarship fund specific to this institution? Now, if it's not specific to an institution, that's where you have to look at things like, you know, private foundation. You have to look at things like a nonprofit organization, public charity of some sort, and you can set it up that way. But if you know that it's going to go to a particular institution, they typically do have agreements set up. I did one when I was working in Williamsport where it was going to a medical facility and it was for a specific type of employee, and they wanted it to be for further education for that particular position. And the hospital was really great about helping us set that up, setting the criteria. We put some seed money in, and then it was funded through the client's will and through beneficiary designations. And so once it had the seed money in, then we were just able to designate that scholarship fund as the beneficiary. And it could be that it was the clients, but anybody who the client knew that might have shared that information. So anyway, I just wanted to share that. It's a lot of fun because usually you get to work with your client, you get to work with the institution, and it's just always, it feels good to be able to help people fulfill their charitable inclinations. So if it's something where you do have a thought where you would like to start a scholarship fund, the first question is it tied to a specific institution or facility? And that's always the best place to start. And then you kind of work backwards and figure out, is it something that we can use what's already existing or what that facility has? All right, the next question is it better to make a charity a beneficiary of a CD or just state that the CD goes to the charity in the will? So first of all, let's talk a little bit about will versus non-probate assets. So anything that's passing through the will is considered a probate asset. Probate is just the process by which the executor is appointed and then will be distributing assets according to the will. That's the probate process. You have to do things like advertise, file the petition to probate, send notices, all that gobbledygook that we have to do. When you have a beneficiary designation or a joint owner or trust, those assets do not go through probate. It'll go to the beneficiary directly designated on the account or the asset. It'll go to the joint owner if it's jointly owned, the surviving owner, or if it's in a trust, it'll go according to the trust provisions. And none of those avenues are going to go through the will. So when we're talking about a charity, there are ways that you can designate a charity with a beneficiary designation. There are ways that it can go to charity under the will. There are ways that it can go to charity when we're talking about a CD. You can do it that way too. So the thing that you have to remember is what's the best asset to get to charity. And the way that I always back into this answer is I look at who are the beneficiaries going to be that are non-charitable beneficiaries. Is it going to be kids? Is it going to be nieces and nephews? And if so, what rate of tax are they at? So for example, I don't have kids. So if I had an estate plan where I wanted certain things to go to my nieces and nephews and then a portion of that go to charity, how I would do it is because I'm leaving assets to nieces or nephews, they'll be subject to Pennsylvania inheritance tax at a rate of 15%. So if I take an asset that like a retirement account, for example, retirement account is subject to inheritance tax when I die, plus as the beneficiary pulls out those retirement funds, they're going to have to pay income tax on it. So if I'm charitably minded, it might be better for me to name the charity as the beneficiary on my retirement account so that the assets that aren't subject to income tax and inheritance tax, those assets are going to my nieces and nephews. So a lot of times I look at charitable beneficiaries going on retirement accounts because that means that you're minimizing the overall tax and making sure that you're getting the assets that are tax-free to the beneficiaries that would be subject to tax. When it comes to a CD, if you name the charity as the beneficiary on the CD, the issue that you have there is typically on a beneficiary designation, you cannot allocate it for a specific purpose with that charity. So if, for example, I wanted it to go to my church and I wanted it to specifically go to the missions board at my church, the issue that I have with a beneficiary designation on a CD is typically I'm just filling out who it is. So I would name my church in there, but typically there's not any place in which I could designate what that would be used for. So the benefit of it going through the will is that I can designate it for a specific purpose. I can say it's going to this church and it's going to be used towards the missions fund. So a will allows you to expand on that, where a beneficiary designation, you typically cannot do that. So in that way, having it go through the will might be more helpful because it allows you to specifically allocate it. The benefit of having it go through beneficiary designation is anything that pays directly to a designated beneficiary doesn't go through probate. And remember, probate's not that difficult in Pennsylvania. It's just that normally the attorney's fees are more when you're probating because there's more things that have to be done to comply with Pennsylvania law. So if I have it going through a beneficiary designation and it not going through the will, usually the beneficiaries, in this case the charity, they're getting the funds faster. So in that way, having a beneficiary designation might be the better way to do it. So as you can see, it's more of what is more important to you? Is it more important to you that the institution or the charity get the funds quicker? Or is it more important that you're able to specifically allocate that to something under the umbrella of the charity? And if you want to give specific instruction about what it's supposed to be used for, then you're better off doing that through the will. The other thing too to think about is anything with a beneficiary designation is not subject to a Medicaid recovery lien. So if somebody needs nursing home care and they die while they're in the nursing home and the assets then pass through the will to the beneficiaries, the Department of Human Services does have the opportunity to recover against the assets that pass through the will. So if I'm naming a charity in the will, potentially the charity might not get anything or might not get as much if I'm in a nursing home and I die while I'm in the nursing home. Where if I'm in the nursing home, yes, my CD is available to pay for care, but if I die, the nursing home isn't going to be able to recover against the CD that pays to the charity. So again, it's a question of what's important and where are you at the time of your death? Are you in a facility or do we have people that will try to recover against the will? All that to say that if you don't need it to go to a specific purpose under the charity, I think you're better off designating the charity as the beneficiary because then you're ensuring it's getting to the charity as quick as possible and you're ensuring that it won't be subject to the Medicaid recovery lien. If it's something where you do have a specific purpose for those funds under the charity, then you probably want to put it in your will. Okay, next question. What is the best way to handle real estate prior to going into a nursing home? And then there's a sub question under that. It says, if transferring real estate, is there a way to assign a life estate or a right to reside for a lifetime? So let's start with the first question, what is the best way to handle real estate prior to going into a nursing home? A couple of things you have to know. The first is that a primary residence is always exempt against nursing home costs. The question is just, are you a single individual or are you married? So if I have a husband and wife, if I have my mom and dad, and my dad goes into a nursing home and my mom is still living in the house, the nursing home cannot force a sale of the primary residence to pay for my dad's care. If my mom is the surviving spouse and she needs nursing home care, the primary residence cannot be forced to be sold. They can't force the sale to pay for my mom's care if when she filed the application to go into that facility, if she put that there was an intent to return home to the house, no matter how remote, then the nursing home cannot force a sale during my mom's life to pay for care because there's a possibility, no matter how remote, that she might move back home. So when we're talking about real estate, it's always a question of, are we talking about the primary residence or are we talking about additional real estate? The next question I have is, if we're talking about the primary residence, even though it's exempt, do we want to make sure that that property is intact to go to the next generation? Because even though it's an exempt asset, meaning a nursing home cannot force a sale, if the primary residence is passing through the will when someone dies, which it would with a husband and wife, when the second spouse dies, it would go through that second spouse's will. So if it's going through the will, potentially the nursing home could try to recover funds against the value of the house, which means that your beneficiaries might have to sell the house in order to pay off the Medicaid benefits that have been paid towards their care. So if we're talking about additional real estate is not exempt against nursing home care unless it's generating income and that income is essential to self-support. So if you have additional real estate, potentially a nursing home could force the sale of that real estate to pay for care. So when we're talking about the best way to handle real estate, a lot of it depends on how important is it that that real estate or the value of the real estate go to the next generation. If that's not a concern and you're saying, well, it's my money, I should be able to use it, then you probably don't need to do anything. The only time you need to do something is if you're worried about protecting the spouse, you want to make sure the real estate goes to the next generation, or you want to make sure the value of the real estate goes to the next generation. And then there are a couple of different ways that you can handle it. So my preference is always to do the most protective way, and that would be to set up a trust and transfer the property into the trust so that we can protect it against long-term care costs. There are other ways you can protect it. So you could add your children's name to the deed if you wanted to. The problem with that is it does make that property subject to your children's creditors. And if your children would pass away, it makes that property now subject to Pennsylvania inheritance tax, and it will go through your child's will. So there are a couple of different ways you can handle it, but I think personally that the best way to protect yourself and your beneficiaries so that the asset is not subject to their creditors would be to use a trust. And the benefit of using a trust is if you create the trust, transfer assets into the trust, they're owned by the trust for 5 years or longer, then they're not available for a nursing home. So real estate is a great asset to protect against nursing home costs because it's real easy to transfer it into the trust. Now, when you have additional real estate, if it is income producing, it's generating some sort of rental income, sometimes you may want to still get that stream of income, and we can set up the trust so that you still get that stream of income and you're protecting the principal value of the real estate. So I think a trust is a great way to go. You almost think of care and protection from care along a continuum, and a trust gets you the most protection and the most flexibility. You can do other things like adding children to the deed, but it's then subject to their creditors and it's not as secure. It doesn't give you as much flexibility. But I would say the best way to handle it prior to going into a nursing home is to consider the trust avenue, or to consider doing it where maybe you're selling it. I'm doing a situation, or I'm dealing with a situation right now where mom is actually selling the farm to the son who helps out on the farm. And we're doing it through an installment sale so that way the real estate's immediately protected against mom's nursing home costs. And mom's just getting a monthly payment from the son that's purchasing it. And the monthly amount she's receiving is going to the nursing home to help pay for care. But the primary residence and the farm is protected against long-term care costs. So that would be the way I would do it. Part of the reason that we offer the free initial consultations, though, is so that we can talk about all the different options and figure out what is best for you. As it deals with transferring real estate into a trust, the sub question under that was, if transferring real estate, is there a way to assign a life estate or a right to reside for a lifetime? Short answer is yes. In the trust, you're going to reserve the right to reside at the real estate. You can do that, no problem. It's the most protective, the most flexible. The other way you can do it is you can transfer property and reserve a life estate in it. So if my mom and dad transferred their house to me, but reserved a life estate, then, and it's been like that for 5 years or longer, then potentially it would be protected against my parents' long-term care costs. Now, the problem with that, and I've actually seen this happen before, let's say my dad goes into a nursing home, but my mom doesn't need nursing home level care. She doesn't need skilled level care. Maybe she only needs assisted living level care. So if the house is sold, then the issue there is if mom and dad reserved a life estate, there's a portion of those sale proceeds that are considered theirs. And because of that, some of the sale proceeds would be available for nursing home costs. So a life estate deed is only protective as long as it stays the real estate. As soon as you have to sell it, then it is problematic, because then those sale proceeds for the amount that's allocated to the life estate are available for your long-term care costs. The other issue with the life estate is that you now have other owners, you have remainder beneficiaries on the deed. And so now you have other people that get to make decisions. You can't just sell the property. You have to get all of them to sign off on it. Where if you do a trust, you can still maintain the ability to sell the property, and you're the only person that needs to sign in order to be able to sell if you're the trustee. So I still think that a trust gives you the most protection and the most flexibility. but you can reserve a life estate in a deed if you would choose to do that. Okay, I've covered all the questions that were submitted prior, and I already know what Jess and Amy are going to say because we made 2 other pages of questions possibly that we could mention during this presentation. And when I was like, we probably need more, they said, Sam, you talk too long and take too long to answer questions, that my guess is we're only going to get through a handful of questions, and they were right. So let me open up the floor. Do we have any other questions for people that are on here today that would like to ask them? If not, I'll answer a couple of more off the list, but I wanted to make sure I gave an opportunity. Anybody on here have a question that they would like to ask at this time? And if you do, you can just unmute yourself. Oh, good. That means I'm being really clear. Oh, Bob, do you have a question? Go ahead.
Yeah, the question is one of philanthropy.
Yeah.
In the past, when we've given to charity, we've done it through our required minimum distributions.
Yes.
And I know for people in our age bracket, Louise and I, the standard deduction on federal income tax for 2023, I think, is like 27,000 some odd
Yes.
dollars.
Because you get
Now,
an additional amount because of your age.
right,
Yes.
right, because age. A lot of people will donate money as just a charitable donation, which would be handled as an itemized deduction. But if you do that, then you're using up some of the 27,000 standard deduction. Whereas if you use the required minimum distribution, you are basically have a separate category.
Yes.
Going forward, if you run out of RMDs, you get to a point where your IRA assets have pretty much been exhausted. At that point, I guess your choice is only to go back to the standard, well, not standard deduction, but as a deducted,
Right.
deductible charitable gift. Is
Yes.
there any other way to handle that to give you maximum tax benefit, but at the same time accomplish what you want to do philanthropically?
Yeah. So, Bob, I'm glad you brought that up. So, just so anybody on this seminar understands, what Bob's talking about is once you reach a certain age, you have to take required minimum distributions from your retirement account. And one of the ways that you can handle that is rather than taking the RMD, you can call your plan administrator and have it go to a charity. So, it never gets added into your adjusted gross income, it goes directly to that charity. And you have to make sure that you're not actually in receipt of it, that it's going, directly from your IRA to the charity that you're choosing. But the benefit is you never had to include that in your adjusted gross income. And the last several tax years, they have allowed that. Now, when I first started practicing, it was something where every year they would pass it, but only for another year. But now it's kind of settled in, and we have this as a reoccurring thing. Because Bob is right, if you don't do that, the only other way that you can give to charity and get a deduction is that you would have to itemize, which means that you lose the standard deduction. You have to have enough itemized deductions in order to be able to take the deduction for the charitable contribution that you might have made. So this Roth contribution allows people that are taking the standard deduction to contribute to charity and not include that RMD in their adjusted gross income. And so the short answer is, Bob, no. Currently, there is nothing that you can do after you've exhausted all of your RMDs. You would have to switch it to itemized and then be able to take the charitable deduction, assuming you had enough itemized deductions to do so. Now, last year, maybe it was during COVID. I'm trying to think, remember exactly when it was. They did give like a free amount for anybody, but it was only like $300 or like $600 that everybody could give, and they would get the deduction. You didn't have to itemize. But they didn't continue that, and it wasn't really enough to make an impact. So I'm not sure, and I haven't seen anything in any legislation that would expand on people that are more charitably minded. So I think if you're not rolling your RMD distribution to a charity, the only other way you can do it is to itemize and take the charitable deduction that way. Oh, Bob, you need to unmute.
Okay, now you should. Okay.
Yes.
If you're forced into that position where you can no longer use RMDs as your charitable contribution, is there currently any threshold or limit on the deductible charitable contributions? At one point, I thought there was something about you could only give up to a certain percentage of your
Yeah.
adjusted gross income. Not that that would necessarily affect a lot of people, but
Right.
are there any other limits?
Yeah, so there is still that limit, and I think it's if I'm remembering off the top of my head, I want to say it's 60%. You can't deduct more than 60% of your adjusted gross income, but that depends on whether you're donating to a private foundation or a public charity. So the maximum is 60%, but if you are donating to a private charity, it's a lower percentage. Like it's like 30%. You can deduct up to 30% of your adjusted gross income. If it's a public charity, you have the larger percentage that you can deduct. So yes, there are still limits as to what you can do. Oh, hang on, Bob, you're muted again. I have such good staff. They're muting and unmuting you at will. Okay, go ahead.
All right, thank you very much.
You're welcome. And Bob, I
And I
always
will
appreciate
mute
it.
myself.
I can always count on you to have good questions. So I appreciate that. Hi, Louise. How are you doing?
I'm doing well, thank you.
Good. I'm glad to hear that. I'm glad to hear that. Anybody else have any other questions that they want to ask? All right, I'm looking at Jess. Do you think I have time for another one? If it's short, Jess says, if it's short, I have time for another one. Let me talk a little bit about what's happening here at our office, because we've gotten a lot of questions about that. And so I wanted to talk about that. So for those of you that have not visited our office recently, and by recently, the last 3 months, I think, we have some new things happening. So when you walk in the door, there is now a little security kiosk that you go to, and it has our logo, and you touch the logo, and it actually buzzes up here to Amy in our reception area. She gets a little noise, and we have a little computer that we answer the call, and your face will pop up on the video, and you'll explain what you're here for. Amy will be able to buzz you in. So I wanted to make sure that clients understood there is that additional security. We certainly appreciate that they're making sure everybody in the building is safe, but I know that it can be a little bit unsettling when you walk into the building and there's that extra step. So once you get through, once we buzz you in, you'll come in, get on the elevator, come right up, and then you'll knock on the door if Amy's not sitting there, or ring the doorbell, and then she'll unlock the door and you'll be able to come in. So they're just making things a little bit more secure now. And when you're on the elevator, you're going to come up to what they've now labeled the 3rd floor. So our suite number hasn't changed, because technically when you get in the elevator, you're going up to floor 2. But what they've done is they've renumbered the basement as 1. So it's now 1, 2, 3. So technically we're on the 3rd floor. And all of this is important because when you leave our office, you want to go to floor 2, because if you go down to 1, you're in the basement, and everywhere you go in our building now has swipe card access. And we've actually had clients that have gotten locked out in our back parking lot, and we had one gentleman said he crawled under the fence in order to get out. So I want everyone to be safe, but I also don't want anyone to have to crawl under fences to try to get out of our office. So I wanted to let you know that, so that you weren't surprised with that. The other thing I wanted to talk to everybody about is that we've had a lot of requests lately to travel to clients, whether it be maybe in the hospital or at their home, and we are happy to do that. Please know that we're happy to travel to you. How we handle that is, if I'm taking more staff out of the office, because normally when we do a signing, we have a witness and a notary, and so we just charge for the time that we're going to be taking the staff out of the office. And we don't charge per person, we just charge a certain amount based on the time we're out of the office. So I wanted to let people know that, but we're happy to travel if we're able to do that. We also do have virtual and phone option as well. And we can always send documents to clients, and then they can take it to a notary and sign it as well. So if this was helpful, please know that we're always looking for new ideas. If this asking just questions and being able to be a little bit more flexible, if this was something you enjoyed, please feel free to let us know, and we're happy to do more of these. Like I said, I have like pages of questions that we already thought of. So if it's something where you enjoyed this more flexible setting, please let us know that. And the other thing I wanted to mention is and just because I'm so excited, I had to share it with you guys. I did have a meet and greet this morning with a gentleman that we're going to try to work into our virtual seminars. He's a clinical psychologist. And I think that those of you who are on our monthly virtual seminars have already heard me complain about the fact that I don't think as a society we're supporting our aging population very well. And so I was excited to talk to him because he was talking about these evaluations that he's able to do that are assessing people and maybe providing support as to how they can maybe stop or slow the progression of maybe dementia or Alzheimer's. And he was talking about other contributing factors, like if he does an assessment and they're noticing that there might be some cognitive decline, things like treating anxiety and depression, reducing stresses, identifying those stresses, diet tips, exercise tips. He said he would be happy to do that. And then things like vitamin imbalances. Like he said, he likes to talk to his patients about how, if you have low vitamin D, that can be causing some cognitive decline as well, or some memory issues, he said specifically. So I'm excited about it. Just know that here at our office, we're going to be trying to figure out the best way to get this material out to you. We might do smaller seminars or do a partnering with a pro. So I always like you guys to know kind of what we're thinking. We did get great feedback from the cybersecurity one. So thank you for everyone who got on that, who offered us feedback. We're always looking for other ideas. So if you think of anything else, you can certainly let us know. What I'm going to do is I'm going to stop the recording and I'll still be on if anybody has any questions they wanted to ask but not be recorded. So thank you all for joining us. This month's virtual seminar was Ask the Legal Lady. I'm Samantha Wolfe with the Law Offices of Samantha Wolfe. Thank you so much for joining us. We look forward to seeing